Hi, everyone. Welcome back to Mike's Minutes. My name is Mike Dunn, a wealth advisor with IPC Securities. As I mentioned in my intro video, the purpose here is to educate my audience on important financial topics. Today, it's my pleasure to have Raluca Soyka, a wills and estates lawyer here in the GTA, back for another episode. Raluca, thanks very much for joining us today.
Thank you for having me. It's my pleasure.
Anytime. Important topics to discuss for sure. So before we get into the topic of ownership, I just want to remind everyone the purpose of these videos is to provide education and not advice, as everyone's situation is different, which is why it is always best to reach out to professionals when it comes to these important topics. So I always say we got to keep compliance happy. I'm sure, Raluca, you know what I'm talking about. So there's my little bit there. So as an advisor, we need to look at many different facets of someone's life before we just invest their money. There are many different situations out there, and doing proper planning can prevent headaches, financial losses, and even family feuds. That said, the way in which a client owns an asset can make a huge difference with someone's estate, which is where we're focusing today. So with that said, Raluca, can you give us just an overview of the types of ownership when it comes to an asset in general?
So it depends what type of asset. So for bank accounts, for example, they can be held joint with another person, or they can be held solely by the testator. If they are held in joint ownership with somebody else, the survivor will receive the benefit of that account. So whatever money is in that account upon the passing of the person, and it doesn't flow through the estate. So that means that the other beneficiaries don't get to benefit from the value of this money, and it just goes to the joint owner of the account. If the account is held in sole ownership, so just by the testator, then upon the passing of the testator, assuming they have a will, it will flow in accordance to the terms of their will. Otherwise, it flows in accordance with intestacy law. And but regardless whether they have a will or not, it will flow to the estate and be distributed either in according to the will or by intestate law.
Sorry to interrupt here.
Yeah.
You mentioned bank accounts, like something that I see a lot of.
Yeah.
Elderly parents, and then they have a kid as joint on the bank account, and they do that maybe for ease of access to funds upon death or something. Like, that's not always the best case? Maybe you can elaborate a little bit there.
Yeah. So for example, I had some clients right now, elderly couple who have two children, and they trusted one of the children to be the executor of their will and estate trustee of their estate. And the other child, they didn't appoint as executor because she's not as good with money. So they felt more comfortable with the first child. So they had all these side agreements as I was discussing with them about their accounts and who owns them, if they're joint, if there's any beneficiary on registered accounts. They started telling me about all these side agreements that they have with the one daughter who's the executor. They were planning to leave her a certain amount of money and add her as a joint on certain accounts, because they had these agreements that, okay, with the money in this account, you pay for the funeral. With the money in this account, you do this. They had all these side agreements. And I had to alert them to the fact that they don't need to have these side agreements. We can plan for this accordingly, so that there's no estate, there's no possible litigation later by the other child who feels that they're unfair. They were being, distribution is unfair in a certain way. The truth is that if a parent adds a child as joint owner to an account, but the parent contributed all the money in that account, a lot of elderly parents do that So
Yeah.
just for ease of administration of the account while they're alive, or to have a side agreement to pay certain things once the person passes away. However, what a lot of people don't know is that these side agreements are not enforceable unless they're in writing. And um, and it's hard to prove that there was a side agreement by a third party, like another child that has maybe wasn't privy to these conversations. So um, then the child who inherits, who ends up inheriting, being the survivor of that account and inheriting the money in that account, they can do whatever they want with the money. They don't have to pay for the funeral in accordance to this verbal side agreement they had with a parent. So I advise my clients to either prepay for their funeral or have, instead of adding the child to the account, just have not to add them at all and just have it flow directly to the estate. The impact on estate administration tax is not as high as clients might think.
Yeah.
Estate administration tax is 1.5% over values over 50,000. It's not such a high tax that it's unless you have hundreds of thousands and millions of dollars, it's not going to have such an impact. So I always advise my clients to think twice if they want to add a child to their account. And the other thing is, if the second, third child, if they bring a claim, the court can easily overthrow what the parent did and have the money flow to the estate instead, because it becomes substance over form. It's not fair that one of the children gets this large sum of money that is in the account and the other child is deprived of it without a reason, so without a proof. If the lawyer has a declaration from the client explaining why they did it this way, that can help substantiate the survivor's benefit. But otherwise, the court can overthrow these, and it just complicates the administration of the estate. It complicates the relationship between the two children that survived, especially if they're battling over money. Fights over money are the worst and the most emotional.
Well, and people change when it comes to money, right? Like, second family, blended families. You kind of see, I'm sure you see a lot of interesting cases, but not only bank accounts, I'm sure on the investment side, like I get clients that want to have a joint investment account, which is usually more assets or more money than just a bank account. And, it makes it very interesting. And my takeaway here, I'm not a lawyer, but, talking to a lawyer is important. And kind of like when I went through my will, I was asked a lot of questions that I never thought of. So it highlights the benefit to working with a professional, and obviously things cost money, but as you were just explaining, I mean, it can get very complex. So just simply working with a professional and making sure that you have things documented and, set up the proper way, it could save your family. Like, I mean, estates could take years to settle if somebody fights.
And this can ruin a relationship long-term for the children.
So like, would you have any comments? I mean, that would, like, ownership with bank accounts and investment accounts, pretty similar. Any comment on the investment account, like a joint account with a child, or, I mean, obviously over 18?
Well, so it depends on the situation. Again, it depends. That's my standard answer to everything. And it depends. Is there a blended family? Did the father of the children remarry, and the children are from a previous marriage? Was there potential for litigation or conflict later on from the part of the current spouse or one of the children? It really depends on what the person's current situation is. For example, if it's one parent that the child, they have one child and the child's other parent passed away, so it's just one parent, one child. The child is obviously helping the parent. with the administration of their finances while they're alive. The parent trusts the child completely. I would say that in this case, and depending on some other factors in their life, it makes sense to add a child on an investment account. But if there's other children, if there's a second spouse, third spouse, minor children, dependents, a lot of things can influence the way an estate is administered and the decision to add a person to an account, and you're right, investment accounts are higher value, so therefore it's more contentious. And it's not fair. And a lot of the times, like I said, parents have these side agreements with the children. I add you to this account for ease of administration. When I pass away, make sure you give your brother so much. And there's nothing to substantiate that agreement, and it's unfortunate for the other child who's not added. So
yeah, in theory, you know, every family hopes that somebody that inherits the money does the right thing. You know, just a short story for the audience here. I reached out to Raluca a couple weeks ago. I was going through a case similar to this. The client had a lot of non-registered money, so this is even more important with ownership. And we were thinking about doing it in joint name with the partner. Just we were thinking mainly for estate planning. But after talking to Raluca, you know, she brought up other things that we didn't necessarily think about. So I went back to the client, and, you know, ultimately it's their decision as long as they're fully informed.
Exactly. Yeah.
But, you know, like at the beginning with the client, it was probate. But then what could have happened if we had just focused on probate down the road?
Yeah.
Could have been way more than, you know, 1.5% of the estate.
Oh yeah. So
very, very beneficial to have that advice and just kind of present the other side of it. But obviously, for the interest of time, we could probably talk about this for 24 hours or so. But maybe, do you have a comment on the other big asset everybody talks about these days is real estate? Like, is there anything to highlight there?
Yeah. So real estate, it can be owned I'm going to talk about 2 ways to own real estate. There's other ways, but that would just complicate. It's beyond the purpose of this discussion. So you can own it in as joint tenant with somebody else. You can add as many joint tenants as you want. It's not just 2 people. Usually it's spouses that are joint tenants. And sometimes the surviving spouse ends up adding one or all their kids to title as joint tenants. And that's the same idea with with the bank accounts that are owned jointly, is that the survivor gets the property through a very simple application. It's called survivorship application. It passes outside of the state. It doesn't, so that means that it's not subject to state administration tax. So it's the simplest way of inheriting property once someone passes away. The other way to own it is as tenants in common. Tenants in common have a divided interest into property. One person, so one owner who's a tenant in common, can even sell their share without the other person's knowledge. And it doesn't pass on survivorship. So if one of the tenants in common, one of the owners passes away, there is no survivor, and that share of the property passes in accordance to the terms of their will or in accordance to intestacy law. A lot of times, if you are a joint tenant, you can actually divide your interest unilaterally and convert it into a tenancy in common. I've seen this commonly done in spouses who are separating, and one of the spouses is afraid that something might happen to them, and then the surviving spouse, who they're planning to divorce, will inherit their share. So then what they're doing is they're severing this joint tenancy and then creating a will where the share of their house goes according to their preferences and not according to survivorship laws. So there's other forms of ownership. You can start adding trusts. I've seen it done where a child is added to title with 1% just to qualify for mortgage. These are beyond the scope of this conversation. It's a lot more detailed conversation, but these are the two main forms of ownership.
Okay. Yeah. So, I mean, for anyone watching this video, obviously, there's a lot of choice, and you know, from this, my takeaway is if somebody wants to own, like to use real estate, because that was the last thing we talked about. If somebody wants to own real estate, and maybe it's not just a simple husband and wife buying a house, then obviously you want to consult with somebody.
Yeah. So sometimes I have clients coming to me very determined. I want to add this one child to title. Or I have had children coming to me and say, I want mom to add me to title. And then I start asking my questions. I need to speak to your mother.
Yeah.
I need to talk to everybody. I need to understand the whole situation. I need to understand if there's undue influence. I talk to the parents. I ask why. Is there other children? I've also had the situation, unfortunately, where I was helping administer an estate, and the mother had added 2 of her children on title as joint tenants, and one child, the third child, was left out from title, and the child who was left out felt very hurt. The main asset of the estate was the house, the real estate property, as is the case with a lot of people passing away these days, because the real estate prices are increasing higher and higher, especially in the GTA, and now even broader than that. And so maybe when the parent did this back in early 2000s, the prices were relatively much lower, and they didn't imagine that they were going to use up all of their pension, all of their savings, and you know, the one person who's left there, and eventually the end result is that there is one child that's left with nothing, and 2 children that are left with this house that's worth $1 million.
Yeah.
So is this fair? You know, when it's not right now, but maybe it was fair in the 2000s when the plan was done. So also revising your estate plan in accordance to how your investments are increasing, whether they're real estate or more or otherwise, is very important to keep it current and keep things fair, if that's what you intend as a parent.
Yeah, for sure. And, you know, for those listening again, if you haven't updated your will, probably a good time to do that. You know, real estate's changed, markets have changed.
And the law is changing now with COVID. Estate law has actually changed quite a bit, with several things have changed significantly. Some law that was more archaic was replaced by new modern law that makes more sense. But still, it could affect someone's estate and someone's estate plan. So.
Well, there's another video for us. You know, important laws that have changed because of COVID. So we'll definitely have to do more. And I mean, we can expand. We can expand on the ownership too. I mean, there's a lot of great information, and you know, obviously for the interest of time, we'll cut short there, but we'll definitely have you back, Raluca, and I appreciate, you know, all this information. And I always say, if anybody wants further information on today's video, you have questions for Raluca, for myself, reach out to me and I'll quarterback that connection. And I always have to say this, I feel weird saying it because I'm not a YouTuber, but if you haven't subscribed to my channel, please do so you can be updated with new content. And as always, I hope you learned something today. I'm looking forward to sharing more information regarding financial life in general. So until next time, stay safe, stay healthy, and stay invested. Thanks again, Raluca, and take care.
Thank you. Bye.
Take care.